most housing disrepair practitioners will know, in 2020, there was sadly the death of Awaab Ishak as a result of mould and damp in a social housing property. And as a result, what has happened is, due to a lot of pressure from his family, and Shelter had a lot of involvement in it as well, there's been a development of a law known as Awaab's Law now. And last week, the government provided some guidance on how that's going to look when it comes into play in, when it starts to come into play in October of this year. It won't fully be implemented until 2027, but we'll come on to that. This is how Awaab's Law essentially has been inserted into the primary legislation, because although it's called Awaab's Law, it's in itself not a law, it's regulations. That's just how it's known. So it was first introduced through the Social Housing Regulation Act, which essentially implies a term into all social housing tenancy agreements that they're to comply with the regulations set by the Secretary of State. It should be noted that this applies at present to registered providers of social housing only. We're expecting to see implementation into the private rental sector at some stage, but I'll come on to that. So this is what Section 42 of the Social Housing Regulation Act says in summary, and it essentially implies a term that the landlord has to comply with all the regulations as has been set out by the Secretary of State. So they're called the Hazards in Social Housing Prescribed Requirements England Regulations 2025, but ultimately they're going to be known as Awaab's Law. And it's going to be introduced into 3 phases, quite originally named Phase 1, Phase 2 and Phase 3. Phase 1 is going to come into play in October of this year. The 27th of October is probably going to be the most important date for housing disrepair practitioners to have in the calendar. And what does that entail? Well, Awaab's Law generally, in every single phase, even the ones that aren't going to be implemented this year, are going to have 2 types of hazards: emergency hazards and significant hazards. For a hazard to be within the scope of the repairing obligation, it has to be part of the building of which the social landlord's responsible. They have to be able to control or fix it. It's not to be damaged as a result of breach by tenant. And it has to result from a defect, disrepair, or lack of maintenance. And it has to be what's known as an emergency or a significant hazard. That's the overall scope of Awaab's Law. What we're going to see this year is the introduction of all emergency hazards, and then regulations in respect of all emergency hazards, and regulations in respect of significant hazards that relate to damp and mould only. There's definitions provided in the regulations as to what an emergency hazard is, and that's defined in Regulation 3 as a relevant hazard that poses an imminent and significant risk of harm to the health or safety of an occupier. An imminent and significant risk of harm is defined as a risk of harm to the occupier's health or safety that a reasonable leaser with the relevant knowledge would take steps to make safe within 24 hours. And ultimately, that is the time frame for emergency hazards. They have to be dealt with within 24 hours of the landlord becoming aware of that. Well, what is an emergency hazard? Because that definition is not all that helpful. So examples of emergency hazards are gas leaks, broken boilers, a total loss of water supply, significant leaks, electrical hazards such as exposed wiring, broken external doors or windows that present a security risk, prevalent damp or mould that's having a material impact on health and their ability to breathe, and significant structural defects or disrepair. The guidance is very clear that this is not an exhaustive list. And also the guidance is very clear that categorisation of hazards does depend to some extent on the tenant in the property. So I think it gives an example to the respect of damp and mould in a property with an old person. You may need less damp and mould than would be in a property with a younger person. And that's certainly something a landlord has to take into account when categorising the hazard that's in play within the property. The guidance also states that where there's other statutory provisions or other policy provisions, be that internal policies that dictate a shorter period of repairs for any of these matters, say, for example, there's an internal policy that say gas leaks have to be repaired within 12 hours, that it's the shorter period of time which takes precedent, and it wouldn't necessarily therefore engage the provisions of the 24-hour repairing period. And then turning to what a significant hazard is, which is probably, in my view, going to be the biggest bone of contention when categorising hazards in properties. I imagine what we will see in practice an awful lot is claimant disrepair solicitors saying that matters should be dealt with as a significant hazard because it is a relevant hazard that poses a significant risk to the harm or health and safety of an occupier. And that significant risk is defined as a risk of harm to the occupier's health and safety that a reasonable leaser with the relevant knowledge would take steps to make safe. And that's as a matter of urgency, but is not the 24 hours. I think what we'll see in practice is a lot of disagreement about whether or not this provision is engaged, and in fact hazards in the property do fit that definition. And ultimately that's going to have to be something that's combated in due course. But I think that's where we will see a big sticking point in litigation. Significant hazards for this year only relate to damp and mould. The government have been very, very clear about that. But what does 2026 entail? Because today we're on the 4th of July and 2026 is not all that far away. Well, excess cold and excess heat hazards are going to be introduced then, as are falls on surface levels and stairs between levels, structural collapse and explosions. I do question how an explosion wouldn't be an emergency hazard, but there we are. Fire and electrical hazards, and then domestic and personal hygiene and food safety. They're all to be introduced in 2026. After that, it's just going to be the remaining hazards that are prescribed under the HHSRS hazards, where they present a significant risk of harm. So in terms of this year and what we know about the introduction in only less than 4 months' time now, the only real relevant issues are going to be those of emergency hazards and significant hazards relating to damp and mould. But it is good to have an eye on these ones that are going to be introduced in the near future. And it'll be interesting to see how claimant solicitors deal with these matters. And that may assist prior to the introduction of the remainder of them. So timeframes, that's probably the biggest question. How long do landlords have to deal with these matters? I should point out that the day of reporting, so the day that the tenant picks up the phone or emails or texts or logs on the portal, whatever they do to report this disrepair, that's day 0. So the next working day is when day 1 kicks in. And what the regulations tell us is, once a social landlord becomes aware, they have to investigate that within 10 working days to ascertain whether or not there is in fact a hazard in the property. After that, and I'll come on to the written summary in a bit more detail, but perhaps what may be seen as a very onerous step introduced by the regulations is that there must be a written summary produced of the findings of the investigation, and that must be given to residents within 3 days of the investigation concluding. 3 working days, sorry. If that investigation finds that a hazard is present in the property and it's not an emergency hazard, because obviously that would need dealing with swiftly within the 24 hours, then works must begin within 5 working days of the investigation concluding. After that, it's a rather unhelpful provision that the works must be done within a reasonable period of time. What that means right now, and in the context of litigation, we just don't know. But that's what the guidance tells us. And it also tells us if the property essentially can't be made safe within that time frame, that residents need somewhere else to stay until it can be. So what are the types of investigations that have to be undertaken? Well, the investigation that I was just referring to, that's what's being described by the government at present as a standard investigation. And that has to be undertaken within 10 days of becoming aware of the hazard. Once that investigation's undertaken, there's got to be confirmation from the landlord whether or not there is a significant or an emergency hazard present in the property. Interestingly, there is provision for standard investigations to be done remotely. It's unclear what is meant by remotely, and it can't be done remotely if the tenant specifically says on the phone, I want a in-person investigation, then it has to be done in person. I originally thought that the provision for it to be remote may be to assist landlords in being able to do this, because often time won't allow for investigations to be done within those 10 days and properly done so. But in fact, I think there's maybe a caution to be given as to doing that. And as I'll come on to with renewed investigations, I think it seems probably inappropriate unless there's photographs or videos from the tenant where it's clear in the landlord's mind that there is a significant or emergency hazard, that it could be done therefore remotely. But if it's unclear or the landlord's position is that there's not, I think it may be best that an investigation of the property is undertaken in person, because there's some further provisions which I'll come on to about having to essentially do the job again, which is the last thing that an already overworked repairs team needs to be doing. So what happens after that is if the tenant requires an in-person investigation after there's been a remote one, again, that has to be done within the 10 days. And that's known as a renewed investigation. But quite differently, if there's a material change to the hazard, something's gotten a lot worse, a new investigation is required. So we're almost starting from the start of the time frame again completely, and a standard investigation is required, and those steps have to be taken again. The time frames also reset again. The government say that landlords are protected from repeated or vexatious claims by that provision because there has to be material change in the circumstance of the property. So it can't be that the tenant just keeps ringing up seeking for essentially a regrading of the hazard. But I'm not sure in practice whether or not that will really guard against that outcome, especially if a property's been inspected remotely. I'm not sure that the optimism the government have is perhaps well placed. And then there's emergency investigations. They have to be done within 24 hours. The emergency regs are a bit more straightforward than what we see with the significant regs. I think as well it will be clear in a landlord's mind if something needs dealing with on an emergency basis. They also can be done remotely. And also if during a standard investigation the landlord has knowledge that it is in fact an emergency hazard in the property, at that point it changes into an emergency investigation. And then finally, in terms of further investigations, on inspection, it may just really be unclear whether or not there is a significant or emergency hazard in the property. And usually that's because floorboards need taking up, or someone needs to go into the loft or look at the roof or something like that. So further investigations can be undertaken if a landlord's unable to determine whether or not there's a hazard in the property, and they just have to be done as soon as reasonably practicable. So again, we're in this grey area where there's no real time frames set past the initial dates. After that, it'll just be in practice or in litigation, those will be matters that are just discretionary, and we'll have to see what judges make of that if there's said to be a breach of the regulations. So a written summary, what does that require? Well, it's required within 3 working days of the investigation concluding. So a very tight time frame to get this out to the tenants. And it has to say whether or not there is a significant or an emergency hazard, and if so, what that hazard is. It has to outline if there's any action required under regulations, and it must specify what that action is and the target time frame for beginning and completion of it. If no action is required at all, then the written summary must specify that and give the reasons why the landlord's of the view there's no action required. And it also must contain information as to how to contact the landlord in respect of that. Personally, I think it would be worth social landlords developing some sort of precedent or working document for this, just with the amount of information that's going to be necessary and the timing in which it's necessary to be delivered to the tenant. It's unlikely that it's going to assist if that document has to be created from scratch every single time. And I know October seems some time off, but it may be worth having in the back of minds that such a document might need creating in order to comply with the regulations. And it just avoids then any satellite issues in litigation about this stage having not been complied with. So what are the defences? Simply put, as having used all reasonable endeavours to avoid the failure to comply. And the guidance says that means they've taken all reasonable steps to comply with the requirements, but it's not been possible for reasons genuinely beyond landlord's control to do the works. And that looks, I think, or how the government plan it to look in practice, is very similar to the defences that we often see in standard section 11 claims, access being the main one usually, but sourcing of materials or contractors, or if the landlord accepts that the tenant needs to leave the property but has nowhere to relocate them to, obviously the onus of all those matters are ultimately going to require evidence. And I would urge, as in any Section 11 claim as well, especially in terms of access, and briefly what Nick touched on when he did his cost talk, where we're now hearing about claimant firms essentially telling tenants not to answer the door and not allow access, that a really good record of access is kept, especially in circumstances where the regulations are so strict. So what to expect when October finally comes? I can't imagine there's going to be a position where we don't see this included in litigation almost immediately. I imagine that there'll be claimant disrepair solicitors all over the country drafting the precedents as we speak, because the timeframes are so short. So we only need to be essentially 16 working days after the hazard has been reported. And if no investigation's been done or the works haven't commenced, then there's a breach of the timeframes that we see. So I imagine what we'll see in practice is, as we often see with 9A and 10 claims as well, that's just thrown in as a general provision. And 9 times out of 10, the 9A or 10 claims tend to be discontinued or are never actually properly being run. We're probably going to see a situation where claimant solicitors just throw the kitchen sink at this. I can't think of a situation where we'll see tenants who are eagerly awaiting for this regulation to come in and waiting to report things as a result. I think in terms of reporting, tenants will just very much deal with matters as are normally dealt with. I think the biggest pressure that will come as an increase is from the claimant solicitors and the increase in the amount that we see this within the litigation. And ultimately, the timeframes are onerous. However we look at it, there is a very pressing need to act, especially if landlords have any suspicion that there's an emergency or significant hazard within the property. Obviously, for now, that only relates to damp and mould, but those in defendant disrepair practice will know that, again, 9 times out of 10, a claim form and a particulars of claim will include some reporting of damp and mould in properties. It's probably one of the most common elements of disrepair that we see. So there's inevitably going to be an increased workload and increased funding to comply with the requirements, and that's obviously something that I would urge social housing practitioners to think about at this stage. Again, it seems a while off yet, but I think the end of October is going to come around. And again, there's going to be an increase in workload in respect of reporting requirements. We don't see these reporting requirements at the moment when responding to Section 11 or 9A and 10 claims, certainly not in the capacity that we see it here, where there has to be a report which details so much information. And as I said before, it would be worth thinking about developing a precedent or something to that effect so it can be quickly filled in and those reporting requirements can be complied with. And rather disappointingly, the guidance that's been published refers to litigation as the first port of call. It does then caveat that and say, oh, well, you can use the complaints procedure, or you can also go to the Housing Ombudsman. But it does appear to put litigation at the forefront of how breaches of the regulations will be dealt with. And obviously we know there's a number of other ways that these matters can get dealt with, but the onus in the guidance, certainly suggests, it essentially says something like, oh, and if this happens, you can sue your landlord. So it's very clearly focused on a litigation approach to these breaches. And with that, there's going to be some guidance for tenants that's going to come out before the start of October. And we don't know what that's going to say, but I imagine that will echo a similar message to tenants who look at that guidance. So that's a whistle-stop tour. I imagine everyone acting for private landlords are thinking, brilliant, what a lot of regulations to comply with. You're not safe, because there's a suggestion in the Renters' Right Bill that this is also at some point going to be implemented in the private rental sector. So I think, I don't have any dates, there's certainly none been published to my knowledge, but I think in due course this is going to be standard practice across all sectors of rented housing.